going on, everybody? Welcome in. Thank you for joining me on my YouTube channel. I really appreciate it. We've got a lot to talk about tonight. We're going to go over, first off, we're going to start with Clayton Echard and Laura Owens case, the latest on that, and kind of have fun at the expense of David Gingras. And then we're going to talk Blakelively, Justin Baldoni, more going on in that case. We're going to bring in Rachel Juarez in a second. We're also going to take your questions as well, like we did last time. All the stuff, info at the bottom. If you want to join in, you want to ask a question, super chats are always pushed to the front of the line. Appreciate that. All that info there at the bottom of the screen. So without any further ado, let's bring in Rachel Juarez. Rachel, how you doing?
Good. How are you? And
now we're going to bring in Mr. Dave Neal.
Oh, oh my gosh. Hold on.
Yeah. Should I change the, how do I do the, there we go.
No. Just,
you need your light on, right?
I got my light there. There we go. Sorry about that, guys. Woo.
There we go. So if I add, let me just pull up the
hold on. You keep going.
The documents real quick. How does it change it? Okay. It just moves us all to the side. Okay. All right. So Rachel, when we last had you on, I think it was a couple weeks ago. Yeah, it was podcast number 427. So it was literally 2 weeks ago.
Yeah.
And Woodnick's brief in response to Gingras's appeal of the $150,000 fine against Laura Owens. So you wanted to wait until Woodnick filed his brief in response to that.
Yes.
So the timeline of events is David Gingras is then allowed to respond to that, and then that's it for briefs. And next is probably oral arguments. So he did that, earlier this week? Last week? End of last week?
Was it at the end of last week, I think?
Yeah, I think Gingras did it end of last week, Thursday or Friday. And there were some things in here that I wanted to go over because, one, some of it confuses me. Some of it, again, is stuff that we had talked about. It didn't make a lot of sense to me.
Yeah.
But I want to bring it up, and I want to kind of, we're not going over all 45 pages of what Gingras wrote because a lot of it is him bloviating like he usually does and saying how great he is and patting himself on the back 100 times. But there are some things in there that I'm just like, the thing is, when David Gingras does a video and includes Laura, even though she usually just sits there and adds absolutely nothing to his videos, I don't understand why he ever puts her on his videos. He literally talks over her the whole time and she's just there, I don't know, to get her face out there. I don't really understand why he ever puts her on his videos. She doesn't really talk or add anything whatsoever. All she does is agree with him. So it could be an ego stroke for him. This is why he puts Laura on his videos. Yeah. But, every time he talks about and he reads his own brief, it's just like, this is the absolute. I'm right. Everybody else is wrong. So I wanted to bring on an actual lawyer who could be like, no, I'm not seeing it the way you are, dude. So I want to start here and let's bring this up. I think I need to make this a little bit bigger. There we go. So this is on page 8. This is part of his preface, which is kind of what he was waiting for. It's why it took a few days to do this.
Yes.
And he's basically just kind of adding in, oh, by the way, this is what happened. And when Judge Mata ruled that Planned Parenthood was open on Sundays, she said it was because Dr. Deans said it during the trial. Dr. Deans never said that. We think she looked online or whatever. So right here at the beginning it says, Clayton also ignores another point, even assuming the court orders the paternity case dismissed. This does not mean that Clayton has no remedy. So I guess my question is that true? Does Clayton not have no remedy? What does that mean?
No, this is correct. It's just, my biggest issue with the reply brief is it spends the first 8 pages, which are your most valuable real estate, on things that aren't important at all. He's absolutely right. Clayton would have another remedy if he wanted to file a new lawsuit for litigation related to litigation abuse of process, malicious prosecution. That's absolutely correct. It's just kind of not really the point. I think he raised this because of a different argument that Woodnick made, which really doesn't have anything to do with filing a separate lawsuit. So, know.
So on page 10, his analogies here with the pipe, I just like, what is he doing here? Does he think he's Edgar Allan Poe or something? What is he doing here?
I don't know.
So anyway, he basically talks about, hey, Laura claims that Clayton didn't follow the requirements of Rule 26, so the award of sanctions was improper. Clayton said the trial court did not sanction Laura under Rule 26. Therefore, her argument is moot. And then he's just saying, look, Clayton's Rule 26 argument is equal parts surreal and it's equal part absurd. So then he goes on to explain why he thinks it's surreal and why he thinks it's absurd.
Mm-hmm.
And again, here, I want you to chime in on this particular point of why he thinks it's surreal and absurd. And is it surreal and absurd? Because I know you don't think it is, but what he brings up as to why he thinks it's surreal and absurd, is it?
Okay. So the issue here is, I think at the end of the day, probably everybody's right. She was sanctioned, I think in part under Rule 26, but also under several other statutes. So it's not that she wasn't sanctioned under Rule 26, although that is what Woodnick is arguing. I'm not sure. I'm not sure I agree with that. The point is, the judge went through several different bases for sanctions and kind of just said, all of these apply and I'm imposing a sanction. So I do think maybe saying that there were no Rule 26 sanctions might be a little bit of a bridge too far, but it's certainly, I mean, this is kind of, I don't know, this is way too much, if you will. You know, I mean, you just lose credibility when you say something is the most absurd argument on the planet when it's not, right? It's just, he spends 3 whole pages of this brief trying to talk about, you know, a painting and why waste very valuable real estate on that, you know, when it's not even really, it's not even really an enlightening analogy, right? It's not like it adds anything. It's just, it's just him saying this argument is dumb.
What a surprise. He thinks the whole case is dumb. He thinks the whole case should have been sent away. And, and I want to get to page 18 here because
stop, hold on first, because I know you had a question. One of the things I think is so important is on on page 13.
Yes.
And this is really, again, what did the court sanction Clayton based on? And more importantly, Gingriss's overall argument that it doesn't matter if fees were awarded under Rule 26, because any fees that were awarded, any sanctions would have been improper. And he cites to this case called Radcliffe, right, which he insists says that if you don't comply with Rule 26, Rule 11, there can be absolutely no sanctions at all. And that is absolutely not what the court said in Radcliffe, right? The court in Radcliffe did not deal with bases other than Rule 11 in that case. What the court did say was, if a party fails to comply with Rule 11, you can't save them from that by the court saying, oh, never mind, the Rule 11 motion was my own motion, which that seems pretty obvious. You know, the court can't say, oh, I didn't care about their motion, I just cared about my own Rule 26 initiative. So it's not at all what it says.
So is he just reading cases wrong that he's saying it is? What is his deal?
I mean,
is he not interpreting cases correctly?
Yeah, it's interpreting cases incorrectly or too broadly or intentionally being dense, right? This case does support his argument in a certain sense. It would suggest that Judge Mata could not be sanctioning Laura under a sua sponte, under her own Rule 11 motion, but he just says it applies to all other types of authority, and it doesn't. So I don't actually think he doesn't understand that.
Can I ask you a question, Rachel? Like what mechanism exists within the law community to shame people that are this, like for instance, in baseball, a bad batting average, you get sent back to the minors. If you steal a joke in comedy, comedians shame each other. You mean we shame each other relentlessly as a joke thief? Is there a hack label you give each other for stuff like this?
I mean, yes, but yeah, but there's really no way that information becomes public. It's kind of more within the small bar community. And we all know which lawyers are the ridiculous ones. We all know which ones are the lawyers that'll lie, which ones are the ones that are dumb, you know, in the small community. But it doesn't really get its way outside of that. I don't know if that answers your question.
Sure, but like, what if you were his law professor and this is what he was turning in for his homework? What, like, do you go, hey, try this again? This isn't it. Like, How does he get this far in life?
You overstated the case. I mean, at the end of the day, Gingras saying that, Woodnick citing a case for the wrong proposition is like disbarable and egregious. This is what law is. It really is. It's writing something persuasive. It's slightly overstating what the case says. He doesn't lie. It's not like he says, the court found X, but really it found not X. He's just overselling what the opinion means. It's all kind of up to interpretation in the law. That's what it is. And so this is not some huge violation of everything that we consider holy. This is just not good legal argument.
It's funny because, when we talk about Gingras and his bloviating, I think one of the things that constantly happens, and like I said, it's not surprising that he misinterprets something or kind of beats a dead horse. But when I go over to page 18, this is something that Dave and I talked about in the months leading up to, like, when we were in like September of October of 2023. And Dave and I were kind of talking about it. We weren't saying it publicly, but privately when we would message each other and say, like, look, if you're claiming you're pregnant, there's literally two outcomes here. Either in 9 months, a baby's going to pop out of you, or at some point you're going to have to claim you don't have them anymore. And then we started getting into months 4, 5, and then it wasn't technically until December of 2023 when this is the argument here that Gingras is making, that, hey, this case was dead and buried for 4 months, and Laura wanted to just move on, and Clayton then hired Woodnick and decided not to let this case go. And Gingras is harping on this so much about he's the one that continued this case. Nobody else. We didn't want anything. Joe Laura didn't want anything to do with this. And I don't think he understands, because he wasn't around until March of 2024, that the reason, I'm assuming, I haven't asked Clayton about this, but I'm guessing the reason he didn't just drop the case when Laura went to him in December of 2023 and said, oh yeah, by the way, I'm not pregnant anymore, is because of the damage she had caused him up to that point, with all of her interviews and her Medium blog posts and her fake stories and the stuff she sent me and the stuff she sent Dave and all the lying. She couldn't just get out of this and say, oh yeah, December 2023, which would have been 7 months pregnant at that point, saying, I'm no longer pregnant. And he's just supposed to be like, oh, okay, let's clap our hands and go separate ways. So this is what it talks about here on page 18. In response, Laura immediately moved to drop her petition, which was then moot. Clayton inexplicably opposed this, putting Laura in a position where she was given no chance to remedy the sanctionable conduct and avoid the sanction. This is where the heart of the procedural error lies. Had the law been followed correctly, trial court would have granted Laura's dismissal request on December 28th, 2023, because Rule 26 gave her the absolute right to invoke safe harbor in response to a threat. That would have terminated the case before either party incurred significant fees. I don't know much about legal jargon, but that doesn't sound right to me.
Yeah, so it's not. And I think we talked about this way back in the day, but everybody knows, right, in this case, Laura was the one that filed the petition, and she asked for some relief. She wanted a parenting plan. She wanted a bunch of other things, right? A declaration of paternity, things like that. Clayton responded and asked, again, very impressively, because he was pro per at the time, for affirmative relief. So his response said, I want something. I don't want to just deny what she's asking for. I want something too. It's like filing a counterclaim, right? We'll get to Lively and Baldoni later, but it's like filing your own claim. It is just basic law that when the other party has a request for affirmative relief pending, you do not have an absolute right to dismiss your case. Of course you don't, right?
I mean, it'd be like if she accused him of assaulting her. He not only wants the case dismissed, he wants proof that I didn't do this. Like, it's so damaging to his career and his
right. Character. So that is something that he very well may not be entitled to, right? If he didn't have any counterclaims or any affirmative claims for relief, it is probably true that she could dismiss her claim, and he doesn't have a right to be vindicated by the court.
Okay.
Right? But after the response has been filed and you've denied the claims, there's no automatic right to dismiss anymore. So whether or not he could have proceeded with the case just to be vindicated, I don't know the answer to that. It would have been up to the court to decide. But it is very clear that once you assert affirmative relief and an entitlement to that, of course the other side can't just drop the case. Otherwise, once I said, oh, I have better claims against you, the other party could just do away with the whole case. It doesn't make sense. And it's not true.
Also, knowing how she's played this card in the past, that she's going to drop it, and then something in the future she might talk about it. Why I dropped it because I was threatened. It's like you just know that you got to stop her, right? You just have to stop this. And luckily, Clayton had talked to these guys before and knew the game plan.
Yeah, absolutely. And that's something the court would have considered if it had, had to get to the issue of Clayton doesn't have an affirmative request for relief. Should we allow him to continue this case just to disprove her claims? And that I'm not sure the court would have done. But this all doesn't matter, right? Clayton's sort of personal reasons for continuing with the case are really irrelevant. He had an absolute right to pursue the relief that he asked for in his response. So she doesn't get to just end the case. She has to go forward with his request for fees, which he asked for at the very beginning.
So what is Gingras after here? He's literally trying to convince people that she had every right to end this case. Is that what he's saying?
Yes.
Here in this?
This is once again sort of there's a limited attractive quality to the argument. Why shouldn't we have just all gone home at that point? Yeah. But the answer is because Clayton had a right not to and didn't want to, right? Would it have been more efficient, perhaps, for everybody to go home? Maybe, right? But he's trying, I think, to make an argument that is legally incorrect because it has somewhat of an attractive quality to a judge, which is, wait a minute, we all just could have gone home. And all of this nonsense, or the majority of this nonsense, was only because he wouldn't let it go. I think that is somewhat of an attractive point to a judge until you read all of the other stuff. And you also keep in mind that that's not the law.
Yeah. I wanted to scroll down to page 28 here. And that's where something comes up where he says, it's about 3/4 of the way down.
Yeah.
Clayton's argument is half right and all wrong. In both cases, the appellate courts did suggest showing a prejudice is necessary, as would be true in harmless error review. So Clayton got that part right. But in both cases, the courts held any ex parte investigation by a judge is always unlawful and prejudicial if used to decide any fact in the case. And he basically goes on to show some cases and then says, in short, the cases Clayton cites do not help his position. They destroy his only argument. So I wanted to go over those cases with you because you looked them up.
Yes.
I'm guessing they didn't destroy his case. This is him being bloviating again. But these cases that he brings up, did they destroy Clayton's case?
No. They were cases originally cited by Gingras that on the whole help Laura a little bit more than they help Clayton. What Clayton was trying to do in his opposition brief was called distinguish them. He raised the cases to say, they don't help Laura as much as she says they do. He didn't try to support his argument necessarily. He said there are aspects of those cases that are helpful to me. And this kind of requires a step back. This is part of the argument that if Mata got any fact that is not in the record, that destroys the entire case. It's called structural error.
Yeah.
And in reading the reply, it became very obvious to me, which it wasn't in the opening brief, which I think is a problem with the opening brief, that structural error could exist here if there were enough to prove that Mata should have been disqualified. That would arguably be structural error. And all these other cases that we're talking about are cases where the judge was disqualified for conducting an independent factual investigation into the case. But it is so important to know what the judges did in these other cases to understand what's going on. And he cites two cases. In one of them, there was a woman who testified, she was a social worker of some sort, to abuse that a child had reported to her by one of the child's parents. And during her testimony, she said, there was a video of the child reporting the abuse to me, but I didn't bring it with me. And after the trial, the judge said, I believe, the abuse happened based on the psychologist believing it happened, and I'm going to make X ruling. But then after that, the judge called that witness on the phone, literally called up the witness and said, I would like to see that video. Will you just send it to me? And the witness sent the judge the video. And if this sounds weird, it's because it completely is. Sent the judge the video. The judge watched it and said, now that I've seen the video, I have changed my mind. I don't actually believe this child was abused anymore. So I'm reversing my prior ruling. And in that case, unsurprisingly, they said, that's really not okay. The judge has conducted this entire investigation on her or his own and had to be disqualified for that reason.
That's not in any way synonymous with what Judge Mata did.
It is not, right?
Close.
For a million reasons. But the biggest one to me is that it was self-evident in that case that the video of the child was the deciding factor because the judge changed her mind.
Yeah.
Like it literally changed the judge's mind, and that was undisputed. The other really key point is the facts at issue in these other cases where the judge does the investigation are disputed facts. Not only are they important facts, but they're disputed facts. Was this child abused in that case? Whether Planned Parenthood was open on Sunday isn't even a fact that's reasonably subject to dispute, right? So, and then just very quickly, in the other case, the issue in the other case was that when the judge conducted an independent investigation, the judge called a bank to find out about their procedures, talked to some teller, and the teller said, oh, here's how we do certain things, and here's whether or not we would have had certain documents. And the judge concluded from that one of the parties hadn't tried hard enough to find documents, and therefore granted what's called a default judgment. She basically ruled that because of that, he loses the entire case. Again, it is not analogous in any way to this tiny little fact about Planned Parenthood being open. That doesn't decide the case. It's not a material fact. It is not a fact subject to dispute. It is not a core fact to make any finding in this case. It's not a required factual finding. So these cases, I think, the larger point they make, which is that judges can't do this, that is helpful, obviously, to Laura. But Clayton points out these cases really aren't anything like what's going on here. And that is absolutely correct.
So what are the odds that these appeal judges, they must be pretty you must be pretty good at what you do to become an appeal judge, right? So what's the odds that they don't see it the way you see it and they kind of take that bait? Because there's several judges, right? So it's kind of like, does he have to win over 1 out of 3? Like what how does that work?
Got to be majority. It's got to be 2. He's got to win 2 out of 3. I don't think these appellate judges are going to take his bait, right? That kind of be fooled into making the wrong decision. They're way too smart for that. You're right.
Do they talk amongst each other? I imagine the voice when they turn their chair around. What's it look like?
It's like Hot Bench.
It's
when you
like
guys
in our show, Dave, which I know you watch all the time.
Yeah,
I'm like Hot Bench, right? And since we all watch every episode, we all know. They absolutely talk to each other. It's also similar to the Supreme Court. They don't have to go into their corners and make a decision and come back. They all chat with each other. Sometimes they don't all agree, but then majority rules. To me, if Gingras wins the case, it's because the justices are going to have some independent understanding of the law that Gingras hasn't really even briefed correctly. Because I don't know how he wins on the basis of his briefing here.
So you're saying if he wins, it's despite anything he's done so far?
Pretty much, yeah. Right? It's because the judges have a much better and more thorough understanding of these principles and how they're applied in Arizona. Or I suppose the one other way he could win is if the Court of Appeals decides we're going to make new law here today. And we're going to decide something for the first time ever, because we all kind of agree there are some unsettled legal issues in the state of Arizona here. They could just say, we're going to make some new law in the state of Arizona and find that Rule 26 provides blanket protection for everything.
I gotta jet out. But can I leave you guys with one thought before I go? Because whenever I can get a chance to take a shot at baby Jingy, I like to. I was watching Harvey Levin, who's a lawyer who founded TMZ, interview Brian Friedman and another lawyer, and seeing 3 competent, successful millionaire lawyers talk to each other felt like, I'd been in a desert for 100 years after leaving baby Genghis and his nonsense. It felt like a breath of fresh air to see what success looks like. So,
except for watching Hot Bench, because that's 3 very. I gotta get the plugs in.
No, I appreciate it. So my point for if Jingy is watching is, man, that free work just must be very exhausting right about now. But anyway, thanks for having me on, guys. I just got to go and feed the baby. We're on a strict schedule right now, so
you got it.
But have a good one. I'll talk to you guys later.
Yep. See you, Dave.
Bye.
So I was going to call you Laura. Jesus. Rachel.
Yeah.
Overall, when you read his brief in response to Woodnick's response to his appeal.
Yeah.
You said that there was a lot of stuff in there that you said was just kind of unnecessary.
Yes.
And did you think that there was anything compelling in this 45-page brief that he did right?
Anything that he did right.
Yeah,
I thought his opening brief was much stronger. I thought, because I think, I found some compelling arguments made in his opening brief. I don't think they're dispositive arguments, but there were some things that I kind of were somewhat attractive. I think the reply brief to me was not strong, and in particular because he spent the first 6 pages like listing these 3 mistakes that they made, right? The 3 factual errors, but then goes on to say those actually have nothing to do with the case or how the appeal should be decided. And it really comes off just like a nanny, like you made 3 mistakes. And he even starts the brief by saying that the court made a mistake about the date on which the case was filed. Yeah. And it's just that is really like this judge is stupid. He. It's just dumb. It just looks like a stupid petty argument, because of course the judge knows what day the case was filed. And if they got it wrong in the order, who cares? It's silly.
Well, the other thing was this whole thing ended up being everything was put on pause because of the whole preface and the Mata thing. Something wasn't filed in time. Explain to everybody what happened this week where Gingras came out and said, like, hey, did Laura lose this case? No, but everything's been put on pause. Explain what happened there.
Well, by the way, I have to say, for a guy who purports to despise clickbait so much, he is the worst offender of these clickbait, topics. I know this is not news to any of us, but so basically what happened was the Court of Appeals said this appeal is not ripe yet. It's a little premature because the court, Mata, did not properly certify her decision as a final judgment. You can only appeal final judgments or some other judgments or some other decisions along the way that are appealable for other reasons.
So her judgment that came out on June 18th, 8 days after the trial took place, wasn't a final judgment, or just technically wasn't written?
Technically wasn't a final judgment. And it wasn't, it actually, the first ruling she made wasn't, because it didn't have the amount of fees that was owed. That came out later, I believe. Yeah. I think she changed it later to add the final amount of fees. It was only not final in the technicality, right? It wasn't like, some more stuff had to happen and it could have changed. But there's very strict rules. It has to be properly certified as a final judgment. Otherwise you can't appeal it. And the court said, you got to go back and have it certified as a final judgment. So, whose fault is this, right? Gingras says this shows what an idiot Mata is, right? A lot of people say it shows what an idiot Gingras is, right? It's really none of these, right? If I were Gingras, I would have done more proactively because he says he spotted this problem, to request the proper certification and ensure the proper certification. But you have to, if you're unsure whether a decision is final, you have to appeal it, because if you don't file your notice of appeal in time, you lose the right to appeal. So if he was unsure if it was final, he did the right thing by appealing anyway. It's just, it's wasteful to not identify the issue, right? That the appeal wasn't properly certified, and seek relief at the time rather than having it go back and forth now.
Well, what was this whole thing in regards to when he wrote in his appeal brief, catching Mata? I think, and we didn't even bring this up when we went over it, and I guess I could bring it up again, but He said that Mata made a mistake in saying that Dr. Deans was the one that said Planned Parenthood was open, but he put that in his latest brief. But hey, man, Judge Mata made her decision and her final judgment June 18th of 2024. Mm-hmm. Why is it only being brought up for the first time now in your brief? Isn't that something that isn't that on him? Why is he bringing it up in his second brief that, oh my gosh, wait a second. Dr. Deans never said this during testimony. And in her final judgment, Judge Mata said Planned Parenthood wasn't open on Sunday based on Dr. Deans' testimony. Oh, yeah. No, it wasn't. Dr. Deans didn't testify this. We just found that. Mata sucks. It's like, but why wasn't that in your original appeal? Because it wasn't in his original appeal, correct?
Which point? The one, the Planned Parenthood one was about it being open on Sunday.
Mata's judgment where he pointed out a certain line.
The other errors, right? The other errors. Yeah. No, that is absolutely something that should have been raised before. And it is very possible that the Court of Appeals will say that those issues were not properly raised. Mm-hmm. And the reason is because not only do you have to raise it in your opening brief, but you have to raise it in the lower court to the extent that it's possible. And the reason for that is obvious, because the Court of Appeals doesn't want you coming to the important guys before you've done everything possible to fix it in the trial court. So if there were improper findings, those should have been thoroughly briefed and objected to, et cetera, in the lower court. And presumably, if he didn't even know it in his opening brief that had happened, he didn't know it before the lower court. But again, these are more kind of beside the point things. His burden is going to be to show that there was a basis for disqualification of Mata. And this whole business about her talking to her dad and doing all of this internet, social media, research, he doesn't make the case to me. She made a mistake or two, right?
Yeah. And you even said just then, all this internet research. No, it was one thing. It was one thing about Planned Parenthood. And he hasn't proven that he's just jumping to the conclusion because it wasn't in any of the depositions and any of the testimony. How could she possibly know this? And you're saying, yeah, maybe she did look it up, but you're making it way bigger of a deal than it is.
It's
not going to be just hard over this.
She shouldn't do that. Let's be clear. But yes, he's making it a bigger deal than it is. And especially with respect to the other things, judges make mistakes. Judges interpret evidence differently. They hear someone, say, I stopped at the red light, but they think they testified that they stopped abruptly at the red light. These are not determinative issues. And these are not a basis to disqualify a judge. And you notice that he did not appeal on the basis, or Gingras didn't appeal on the basis that she made factual errors. And the reason for that is obvious, because these would not even approach that standard to reverse on that basis. That's why you don't see an argument, the judge made so many mistakes.
But he's using all these errors to say she should be off the bench and disbarred.
Right. Because that's how far he has to reach, right? And I think that his raking of Mata over the coals is one of the most sort of legally dishonest things that he does. Judges make mistakes. We lawyers have seen bad judges. To suggest that Mata is the least ethical, most horrendous judge of all time because of anything that happened in this case is really legally dishonest. I don't think there's any way even he believes that.
Well, I was going to say he might not believe it, but he shoves it down our throat any chance he can get to tell us how much Mata is a cheater and all this stuff. And it is really weird because you say judges make mistakes, but in his eyes, these mistakes, he's saying she should be off the bench, lose her robe, disbarred. Every robing room review that she's gotten is totally correct. He's acting like this mistake is equivalent to the case you went over earlier, that after the case, Mata picked up the phone and called Clayton and had a 2-hour conversation with him and his family or something.
Yeah, right. That she went and held she went to like the recent JFC meeting and said, tell me all the facts I didn't get, in this case so that I can adjust my ruling. This is outrageous. And so are his claims that, Woodnick miscited a case and he should have to file a notice saying he lied. Like, people have different interpretations of cases all the time. It's really ridiculous. And it is bloviating, like it should be the textbook definition.
Yeah, it really seems that way. So the next step from this is there's going to be
correct whatever happened down in the lower court. They've got to correct the issue, make sure that the order is, properly certified. They're not going to rebrief the case. That's just not necessary. They'll fix that issue. I don't know the procedure for fixing that issue because I'm not an appellate attorney, but Gingras seemed to suggest that it's very easy in Arizona, which is lovely if that's the case. In California, I can guarantee you it would take months to get that fixed. But either way, it could take months. It could take, a few days. It could be done formally or informally. I don't know. But then we'll just pick up where we left off, and then it's oral argument.
And that will be 30 minutes for each counsel, right?
Maybe, like I don't know. Is that Arizona appellate procedure? 30 minutes.
I thought I've heard 30 minutes somewhere.
That sounds very reasonable amount of time. It's more than you would think it is. Actually, 30 minutes is a lot of time. It's not a lot of time in a trial, right? We saw the trial with Clayton and Laura, which felt like it went by like this because it was only a couple of hours. But 30 minutes of appellate argument is a lot of time.
And that's both attorneys arguing in front of the three judges?
Correct.
Yeah. Will we get to see that? Will it be like live streamed?
Oh, good question. I don't know if the Court of Appeals of Arizona makes it public. Probably not, but
afterwards
they could do
afterwards. Will there be any sort of transcript, or we can read what
they
said?
There'll definitely be a transcript to read, and it's very possible. Most state courts they don't have a set in stone rule about whether or not you can, broadcast. It's usually up to the judge, right? Federal court, very strict rules, but my guess is if there's a lot of interest, somebody may ask, let's live stream this hearing, and it'll be up to the appellate justices. I'm pretty sure they wouldn't live stream them all as a matter of course. That can't really be the case, I wouldn't imagine, but we'll see. I'll try to figure it out and tell you.
And then once oral arguments happen, then we just wait until the appellate court judge's decision.
And it's not quick, usually.
Yeah. But it would, I know you can't give a definitive answer, but it'll happen in 2025, right? You would think? I
would think so. Yeah. In Arizona, probably. In California, maybe not. But I would think so. A year should be enough.
Yeah. And so then we just wait. And then at that point, again, he seems to think that this could be ending going into a Supreme Court case if they lose. And this could end up being what's the word? Published? Is that what it said?
Published opinion. Correct.
Published opinion. That this case is so big in his mind that this could be published opinion at some point. Do you think that is possible?
I think there's a very, very small chance of that. To me, this does not. There's no novel legal issues really being raised here that are so important. And also, the other thing that is important to know when a case is published, right? When you publish a case, it becomes precedential, right? Other courts have to follow it. When you have a case that if you made it precedential is really kind of an outlier in terms of crazy facts, and it doesn't have a good basis to sort of make new law or enrich current law, sometimes that makes it more attractive to publish, but sometimes it makes it less attractive to publish, right? Because maybe the court doesn't want to set a general precedent that, anybody who, decides to litigate after they find out they're not pregnant can get $150,000 in fees. But maybe they think in this case it was fine. So they don't want to publish a case saying that's okay because they don't like sort of the precedent it will set. But I just don't see there being novel issues that would make it worthy of publication.
And then if the appeals court, whenever it may be, sometime in 2025, just says, hey, appeal is upheld, judgment stands by Mata.
Yeah.
At that point, Laura still owes $150,000.
Correct.
And then he decides whether or not he wants to take it to the Supreme Court. He thinks it's absolutely a case that the Supreme Court would take. Like you said, you highly doubt the Supreme Court would take this case. But at that point, I mean, this thing is over, right? Unless Clayton wants to file some sort of civil defamation case against Laura.
Right. And so you can't file a defamation case because, or at least based on what happens in litigation, there's something called the litigation privilege, which means that actions you take, things you say in the course of litigation cannot be the basis for a defamation claim. Otherwise, everybody would sue everybody for defaming them in their public filings, right? But there are certain torts like abusive process, malicious prosecution that he theoretically could sue her for, although they're very hard to establish. And frankly, I understand why he went forward with this case completely. But at this point, public opinion is so far on his side. I feel like he has done his work, right? Does he have a potential defamation claim for things outside of the litigation? Very possibly. But he has literally 99.9% of the public on his side. I don't know why he would spend all that money to file a lawsuit and continue this for another 2 years of his life.
Yeah, I guess it all depends on, because if the judge rules against, she's going to continue saying what she has all along. The judge may have ruled against me, but I'm telling you, I wasn't pregnant. She's just going to continue to say that.
I was pregnant. Yeah.
I was pregnant.
Yeah. Yeah.
The judge doesn't think so, but I know my body and I know I was pregnant. And she's just going to continue to peddle that lie around. And then it's just, at that point, I mean, I guess she can say whatever she wants, but is there anything that he can do in return if she keeps saying that?
I mean, I guess, so saying that she was pregnant, I'm not sure that makes that a defamation claim. Some of the other things she said certainly would, but the bigger issue is, what does he have to gain from a defamation claim, right? The two big things you have to claim, that you have to gain when you file a defamation claim is, one, money, right? Which is going to be impossible to collect from her, right? Even if he gets a huge judgment, and he's going to have a ton of attorney's fees to pay that might wipe out anything he could recover. And he's also going to have to show actual economic damage. So the money is not a good reason to do it. And the second is to turn the tide of public opinion, right? As we've seen in Lively, Baldoni, a defamation claim can be a public, not in a bad way, but like a, public media play.
Yeah.
He doesn't need that. Everybody, he can only go down from where he is right now, because I think the only two people that agree with Laura are Laura and Gingras, and he's not going to convince the two of them, nor do I think he really cares. So yeah. I think it'd be nice to see him vindicated in that way, but it doesn't really get him much.
Okay. Yeah, I think, I'm not going to say we're not going to talk about this case for a while, but there really isn't anything to add. I mean, maybe after the oral arguments, and we get the transcript of that, and we can see what each of them said, but we kind of know what Gingras is going to say in oral arguments? Isn't it going to be kind of a repeat of the brief he just had?
Absolutely. Right? There's a very good chance that it will be. It sort of depends, right? It depends on the bench. It depends on the three justices, right? It could be that that the three justices, or one or more of them, really dives into this and says, well, wait a minute, I'd like to sort of go off on all these tangents and figure out kind of how it would work if we ruled this way, how it would work if we ruled that way. Or it could just be each of them giving a 30-minute speech and then sitting down. It really depends.
Okay.
Yeah.
Apparently, just got a text from my IT guy here. Appeals court has a page for video.
Oh,
yeah.
So they live stream all of the oral arguments.
I would assume it maybe would do all of them, but there isn't a page for it. So, yeah, I mean, it's something that obviously we'd all tune into at the time.
Oh yeah.
All right, let's transition into talking about the Lively Baldoni case, which is, I've lost track of how many lawsuits have now been filed. I want to say that Blake filed one, right?
Mm-hmm.
But there's been 5 against, either 5 from Baldoni's side, 4.
It depends on how you count them, right? It depends on whether you count a counterclaim as a new case. But yes, there have been a bunch of different cases filed. But it's also been very clear these are all going to be consolidated into a single case for trial. And that's the one thing I think that they agreed on from this last hearing is everybody agrees that we should not be having separate trials here.
Yeah, no.
There should be one trial.
Now, when this first was brought to anybody's attention, basically, I can't even remember what happened first, the New York Times piece or Blake Lively filing her complaint. It was right around, I think it was
the New York Times article, I'm pretty sure, because the first complaint that she filed was the CRD complaint, the sort of administrative complaint. And that's what they were basing it on. So I think that was the first thing to come out, was the New York Times article.
But either way, they were very close to each other.
Correct, very close. Yeah.
And when that all came out, it was like, oh my gosh, Justin Baldoni sexually harassed Blakelively on set of It Ends With Us. What's bizarre about this whole case, among other things, is this case has completely turned into in the beginning, it was, did Justin Baldoni sexually harass Blakelively on set? It is now turned into, and pretty much what 90% of the people are talking about when it comes to this case is not even talking about what happened on set, is, are Blakelively and Ryan Reynolds bullies? And did they try and just steamroll the whole production of this thing, take over everything, try and push Justin Baldoni out essentially as a director, and want to make everything about themselves in this movie? And that's all anybody's talking about right now. And it's because Blake, I don't want to say hasn't fought back, but she hasn't gone on the offensive like Justin's defense has. Putting all this stuff online, throwing all these attachments out there, showing a gazillion text messages, and showing the 10-minute video of the outcuts from that scene. It's been two wildly different strategies that are going on here. And whether you like Brian Friedman or not, the strategy is certainly working for Justin Baldoni, because I'd say 85 to 90% of the public believes him now.
Yeah, and I have to tell you, I'm not even sure they are two wildly different strategies. I think that it's the same strategy executed well and poorly, right? I mean, clearly this was, we've seen all the internet sleuths come out showing that this was something in the works with the New York Times for a while.
It clearly was. You can't have a hit piece come out a day after a complaint that's that long and has all these details. Yeah,
right. And I really believe that the administrative complaint was only filed. It seems to me, I don't know, obviously, but that it was only filed to sort of give cover to the article. Like, look, there's an administrative complaint filed. This is a proper legal proceeding going on, as opposed to just being wild speculation, right? So they came out. I mean, this was a media press by Blakelively in December, right? It was all coordinated. They had a complaint ready to go in the court, not just in the administrative action. And they coordinated for a while with the New York Times. So everybody's kind of focusing on the fact that, Justin Baldoni's, Ryan Friedman, and they're out there putting all this information out in the public, forgetting that she started it. I mean, she was the one that said, let's try this case in the public, not him, right? She didn't file a lawsuit and have some runner pick it up and say, oh my God, look at this, right? She orchestrated it to come out with a huge New York Times hit piece. So it's really, I think, just blown up in her face because somebody executed the strategy way better than she did.
And when you say blown up in her face, I've kind of thought that because she's Blakelively and because she's Ryan Reynolds and they are a absolute power couple, if not the power couple in all of Hollywood right now, that I think they thought, this is just me kind of spitballing here, but I think they thought, well, we're so above Justin Baldoni in terms of the power we hold in Hollywood. He's never going to fight back. He is not going to dispute this. And not only did he dispute it, he came back with receipts. And I feel like they were either they didn't think he was going to do that, or they didn't think that he would come back with so much detail, because everything that he has thrown back, whether it was the video, text messages, emails, all that stuff, he said Blake hasn't come back and said, okay, he says this, well, I'm going to respond with this. She hasn't come back with anything. We're still waiting. Now, she might have a shit ton of evidence, and maybe that's what they're waiting for. She might.
Yeah.
So that's why I don't want to say for sure she's getting killed. She's going to get killed in this case. I mean, her reputation has already taken a she's getting killed in the press. Her reputation has taken a hit, and I don't even know if she can get that back. But legally speaking, we don't know. Maybe she's got a whole pile of stuff that she's ready to unload. But the stuff that Justin did, you saw this text the other day, and I thought this was fascinating. Let me pull that text up.
Yeah.
This text where she was talking about rewriting the rooftop scene.
Yeah.
and she sent him this text, and she was basically saying, I can send you my pass at the roof or just read with you when we get together next week. Let me know what you prefer. If you know me in person longer, if you knew me in person longer, you'd have a sense of how flirty and yummy the ball busting would play. And she's basically talking about the rooftop scene where Lily is just busting Ryle's balls over it. She says that. She says, it's my love language, spicy and playfully bold, never with teeth. And I'm sitting there going, how is that not flirting with Justin Baldoni? Like, you're a married woman with 4 children, and you're talking about being spicy and playfully bold, never with teeth. Now, maybe I took that and my mind went somewhere with that, or maybe she was just saying with teeth as in, what's the word I'm looking for? You know what I'm talking about here?
Yes, with oomph behind it.
With oomph behind it, exactly. Yeah. When you read that text, is that the way you took it? How did you take that text?
So I took it less as flirty and more as someone who clearly was comfortable being out of character when discussing things like this. She said, it's my love language. Doesn't she mean herself?
Okay.
Right. So to me, it may be flirty, may not. I've seen the theory out there that, he rejected her advances. Who knows? Right.
Yeah, we don't know.
But
I mean,
to me, one of the big things she complained about was, instead of just staying in character, he jumped out of character and asked me what I like in bed. And he asked me about my relationship with Ryan. I mean, this to me shows that, no, this is what they were doing. They were having communications like friends would. Maybe they're flirty, maybe they're not, but they're having communications about themselves in a completely safe environment. Somebody, to me, who's feeling unsafe and harassed does not send that text message, right?
Yeah.
Whether or not she might giggle if she feels unsafe is different. I have a hard time seeing someone who feels they have no power sending that text message.
And this was sent in April of 2023. So other stuff could have happened. Like I said,
yes,
the stuff that he has shown us in retaliation to what she is claiming in her complaint doesn't make it seem like it was, like we talked about this last time. It seems more of, if this all went down, it seems more of he may have made her uncomfortable in certain situations, but it's not on the level of sexual harassment. Right. But again, we won't want to tell Blake, no, you weren't sexually harassed, and maybe she felt that way. But it's just like what we're seeing right now just isn't adding up to what she's complained about or put in a complaint.
And you said earlier, you were talking about maybe they just thought he would lay down. I think there's 2 issues there. I think first, everybody knows that a lot of times, perhaps rightfully so, you can't come back from one of these like Me Too claims, right? They're the kind of things that sometimes once they get out there, it doesn't matter what you say. If it's, oh, but she, consented to it or this or that, you got a label on you. And in this, it's wonderful that victims are now believed more than they used to be, but it's, some people would say it's gone too far. We don't need to make, pronouncements on that, but it is very obvious that it is hard to come back from a claim like that, even if you're ultimately vindicated.
Yeah.
But also look at what happened when they were making the movie, right? I mean, it appears she steamrolled him during the movie, right? I think she had every reason to believe that she could just steamroll him again. And I don't necessarily think that he wouldn't have responded, but perhaps come out and said, oh, let's just settle the case instead of hiring Brian Friedman and going on the offensive.
Yeah.
I think they had every reason to believe he might have just kind of slinked away like he did to the basement during the premiere instead of fighting back.
Is there a way? I mean, obviously she's losing the battle in the court of public opinion, and that's just more about her and her reputation and does it affect future work for her? But legally it doesn't mean anything if she's losing in the court of public opinion, because she might win a case if it does go to trial. But you and I are both under the assumption that it's really hard to believe that this thing ever gets to trial, right?
Yeah.
Just doesn't seem like, because, and you think trial would hurt Blake way more than it would hurt Justin.
I think it would hurt her. I think from what we have seen so far, I have a hard time believing that Blake has a bunch of silver bullets or like arrows in her quiver and is just like not fighting back publicly because she believes that this shouldn't be litigated in the court of public opinion. Now, I just don't believe that. So I'm of the assumption that what we're seeing come out is somewhat representative of what we're going to see at trial. We don't know that for sure. So in that sense, I think she would be harmed more by trial. But at the end of the day, he would be harmed more financially. Neither of them is going to benefit, I don't think, from spending millions of dollars to go to trial here. I really don't see that happening.
Is there a way? Do you think there's, I was just trying to think, is there a way that she fixes her reputation on this? Or is it damaged based on the stuff that he has put out on the website and put out in attachments?
Yeah. If she has these silver bullets that have been hiding and puts them out, I think a lot of people, for better or worse, are, and maybe rightfully so, are keeping an open mind. And maybe people aren't keeping an open mind, but they sway with the tides, right? They believed her completely when she came out with it. And then they believed Justin when he came out with his stuff. So yeah, I do think if she produced a bunch of evidence, look, here are all the HR complaints that were made by all the women that felt uncomfortable by him back in February, sure, the tides could change, but it sure didn't seem like she has all of that.
Yeah, which she put in her complaint. Like, it wasn't like she was the only one, according to her complaint, that was suffering at the hands of the behavior of Justin Baldoni and Jamie Heath. Apparently they were just being pigs and being perverts on set, doing whatever.
Yeah.
Well, we need to start seeing how some examples, like you said, can you get us some HR complaints that were made at the moment, not well after the fact or during the time? Like, it just, we haven't seen enough from her, and he's delivering way more than she is. And it makes you think, like, why isn't she almost defending herself at this point? I know her lawyer is saying, well, we're going to do it, by the book, in the court of law. We're going to do it the right way. We're not going to stoop to their level. But they're winning.
If that's what you're doing, you're doing a real disservice to your client, because this is what matters is the public war, right? And, the other thing that I think is really interesting, it is true that at the beginning, a bunch of people from the movie came out in support of her generically, right? But to me, if I'm on that set and everyone's being, or some people are being sexually harassed by this director, and it's an unsafe work environment, and somebody speaks up on behalf of me and the other women on set, and then is getting dragged through the press for being a liar, and he is the one that's coming out roses, I'm coming out and saying, not generically like, I love Blake. I'm coming out and saying something, right? I'm coming out and saying, it is true. He was harassing everybody on set. All these people that generically supported her, I think if they really could corroborate those claims, we would have heard from somebody. I really, really think.
Yeah, that's what I'm wondering. I'm wondering, because they did support her at first with just, Justin Sklenar put out a link to her complaint and said, for the love of God, read this. Jenny Slate, who played Ryle's sister in the movie, she said she supports Blake, but again, never gave any examples. It's just like, here, read this. Jenny Slate didn't say, yeah, I saw it. And now, maybe they are going to say it and they've been told, wait, but considering how much Justin's gone on the offensive, you would think, okay, maybe they did tell him to wait in the beginning, but that was before, because Jenny and Brandon defended Blake before, I think, Justin came out with all of his countersuits. Yeah. So you would think by now they would have been like, okay, wait, let's change up our attack here. Will you please come out and say something and give specifics of what you witnessed or saw or what happened to you on set?
Yeah, because if this really is a situation where he was, abusing his power, sexually harassing women on set, then what's happening in the public right now is unconscionable, right? If that was really what was happening and all these women felt unsafe and he was sexually harassing people, they should be horrified that he's winning the public media war. right? I mean, they should be saying, I can't believe he's found a lawyer that has spun the whole story backwards and has, pushed all of the sexual harassment under the rug in favor of something about whose director's cut matters and whose doesn't. I would think that somebody would be out there saying, you can't let them fool you like this. This is the most offensive thing I've ever seen.
The judge ruled on Monday, finally heard something, the legal side of things that happened on Monday. Explain what the judge said on Monday and what the next steps are going to be in this case.
Right. So, again, and this also to me kind of is emblematic of what we are likely to expect in terms of evidence. Both lawyers came out and said, oh, this was a victory today on the issue of making public statements. Right. And to me, that was so disingenuous from her attorneys to say the judge ruled in our favor that that you have to follow the law. Right. What happened was she asked for a gag order and the judge said no. And then the judge added, which happens all the time, but I'm reminding everyone that we do have to follow the law and the rules, that counsel are required to follow in every case about speaking to the public. They lost. And for her lawyers, I understand why they're spinning it. But it gives me a little insight into, into whether or not the truth is likely to support one side's version of events or the other. So anyway, so what the court said was basically the court wants to get through the motion to dismiss stage effectively before doing any significant discovery. Some discovery can go forward, but they have to settle out which parties are actually going to be in the case. Are some going to get dismissed? Are there going to be new plaintiffs? Are there going to be new defendants? Get everybody involved, deal with motions to dismiss. And one of the issues that came up was, can Blakelively resist having her deposition taken by Brian Friedman?
Yeah.
And her side again came out and said, we were successful in delaying her deposition. Well, the judge did say she can't be deposed until we get a little more clarity that all of the parties in the case are here and represented and have appeared. But the judge also said she's not going to get to choose who deposes her, which means Brian, they tipped to their hand, which means Brian is going to depose her because they know she's scared of him now,
Yeah.
And that's not to me a big win, because I would have been shocked if the judge had let her control which attorney takes her deposition. But, he basically said, you have to adhere to your legal responsibilities about speaking to the press. And the more that comes out in the press, the faster I'm going to make this trial move forward.
I was going to say, that was one thing the judge said, threatening to move up the trial. Does that favor one side over the other?
No, I don't think so necessarily. I think that, I guess you could make arguments for either. I think it's going to put a little bit more monetary pressure on everyone, which I think favors Blake. At the same time, if discovery moves forward, it would certainly seem like Justin is going to benefit from the discovery phase. So it's kind of hard to know. But I would have a hard time imagining that this case goes to trial sooner than the trial date that was set. It can certainly be done, but I think that was more of a statement that very often the first trial date is not the trial date. And to me, it's more of a sign that he's not going to let this languish in court for 3 years.
What was the first trial date? Was it March of 2026?
2026, yeah.
But
I don't know. What was it, May?
Did it give a month and a year? I know it was 2026. But
somebody must know. And it's the first half of 2026. I can probably figure out.
Yeah, I don't even remember if it was a month. Or it was
March 26.
March of 26. Okay.
Yeah.
Originally.
And federal courts are much more efficient than state courts. And, they expect a lot more of their litigants and of the attorneys. But I would have a really hard time imagining a case of this magnitude, unless it gets narrowed significantly, being trial ready sooner than March 26.
Is there anything that Blake's side is doing ever since they released the complaint, when, I don't know, everybody, like you said, kind of sways with the public? When that first came out, everybody was pro Blake and anti Justin. And then all of Justin's stuff has come out, and now it has swayed in favor of him. Is there anything that Blake has done, either legally or on the public relations side, where you think that she has done something right? Because it seems like she's losing everything, because every time Justin does release something or Brian Friedman does an interview, Blake doesn't respond. The lawyers don't really respond, and they speak in generic lawyer speak. They don't combat with everything that, like we said, Justin is throwing out videos, emails, text messages, trying to say, like, she said this, here's our proof that what she presented it as is not the way it seems, and here's the response. And then she hasn't responded back to that. So
it's
I feel like
question.
They're getting creamed.
Maybe the good thing they've done is not saying more when they're just going to dig themselves a deeper hole. I mean, the few things that they have said, I think, are, questionable, right? And so, maybe it's good that they're not responding and digging themselves into a deeper hole or looking more ridiculous. If they don't have the goods, if they know they have the losing case, then probably not saying anything is smarter than saying things that are going to be proven false or saying dumb things that are going to subject them to more ridicule. But it just really seems to me like she should be looking to end this now and move forward.
And and then God, if she ends it now, without revealing anything, like, she's going to just take the giant L on this, because like we said, 90% of the people are on Justin's side now and think that her and Ryan are the biggest bullies in Hollywood, and they're elitists, and they absolutely tried to ruin a guy's career and his livelihood. Like, that's what everybody thinks of Blake and Ryan right now.
Right.
So if she ends it right now, that's the lasting impression, that they are leaving. Does she want to do that?
I mean, what's the difference? What's the alternative, right? Certainly, if she has more evidence, don't end it now. Get that evidence out one way or another.
Yeah.
But it's hard to see a path where this gets better for her unless there's a bunch of evidence we haven't seen.
Yeah. And
right?
that's like just the one thing we're kind of all waiting for, because when her complaint first came out, it was just like, wow. How is Justin going to respond to this?
Yeah.
And then we've seen 178-page filing and a bunch of emails and text messages and setting up a website. And he did respond to it, and everybody now believes him because he's backed it up with evidence. If he would have just came out and did a statement or did an interview, it still would have been a he said, she said. And I think people would have still leaned towards believing Blake, because we want to believe women when they come out like this. And this is, this turns into the whole Me Too movement. This is why women don't come forward. And people are saying, the people that are in favor of Blake are saying, well, what did you expect her to do? Just not say anything? This is how she felt that she was treated on set. I support Blake for speaking out when most women would have kept their mouth shut. And it's like, okay, I see that argument, but you also have to be able to see the other side too, which is he's allowed to defend himself if she's going to come out and throw all this stuff against the wall against him.
Right. And, it also just really feels like it's going to be hard for her to get away from the fact that this was a publicity stunt or a publicity move, right? Because the timing and the way that it was done, this wasn't like she went quietly and filed a complaint in court and somebody picked it up and then she said, you know what, I'm not going to comment on this. I'll litigate it in court. And then he made a big deal out of it. I mean, she came out aggressively with and I get that. But what we're seeing now is not just him denying it, but specific evidence, like the video on the specific allegations she made. And how is she going to come back from that? I don't know. If she has the evidence, my God, they should be putting it out in the court of public opinion.
And it kind of goes to what we talked about. One of the biggest questions we had the last time we talked about this was, and this is like one of the big things that needs to be answered now is the why. Why does Blakelively literally not just come out and say, had a rough time on set with one of my co-stars, didn't do a podcast interview or a interview with 60 Minutes or something like that. She literally had a hit piece ruining this guy's career and his livelihood, and filed a complaint against him and then a lawsuit suing him. So that's a big deal. And so the question is, why, when she's Blakelively, married, Hollywood A-list couple, against a guy who most people didn't know the guy's name before it is with us.
I didn't.
Yeah.
I'd never heard of him.
So what's the why behind this? That's what's killing me is I don't know why. And some people will say, Steve, the why is she was treated shit she felt harassed on set. And rather than most women who don't come forward because they don't want to rock the boat, they don't want to be looked at as difficult, she is standing up and women's empowerment. And this is why. And this is why she did it, because she felt she had to, because the way she was treated on set. Okay. I mean, I guess that's your why.
If you feel you have to, then the media approach, the public relations strategy was all wrong.
Yeah, it's terrible.
All wrong, right? And, you know, I don't know if that's because whoever did her public relations campaign didn't know the truth or, you know, but I do sort of have a lingering question. I know there have been theories out there that, you know, she wants the rights to the second movie, that she was feeling so butthurt by all of the bad press that she just couldn't let it go. But that's the biggest open question to me. Why do this?
Yeah.
But people do stupid stuff all the time. So, you know.
But she doesn't need to. Like, if it was the other way around, it would have made more sense. I don't know. It would have. She didn't need to do this.
But you can say the same thing about kind of taking over the movie and forcing herself to become the director. She didn't need to do that either. You know, I mean, it was something she decided she wanted to do for one reason or another, and, you know, did, right? So I don't know. I agree. That's the one question I feel like it's not necessary to know, but they're going to have to, if this goes to trial, they're going to have a very clean argument as to why she did it. Not have to. I shouldn't say they're going to have to. I would want them to have one. I'd want them to have a reason, because that's going to be the lingering question. Why would she do this if she wasn't harassed? She could have just, you know, she won the public media campaign in terms of being able to go forward with her cut of the movie. She was the one that was promoting it. The movie was a big success, and the negative press on her seemed to kind of really fly under the radar. So why not just let sleeping dogs lie and move forward?
Yeah. And that's what's been one of those confusing things. I guess the final topic in regards to this whole case is the Taylor Swift aspect of it. And this has nothing to do with me being a huge Taylor Swift fan. You obviously attended a concert with your daughter. You're a Taylor Swift fan. I feel like everything involving Taylor Swift in this seems to be unnecessary. Like, I don't even know what she did wrong here. I mean, Blake was the one that sent the text about, hey, I've got two dragons in my corner and I'm Khaleesi or whatever. That's Blake. That wasn't Taylor's texting Justin saying, hey, I'm going to bat for my friend. Don't you dare do that. Like, it doesn't seem like Clayton. It doesn't seem like Taylor has involved herself in any of this. It's been Blake throwing Taylor's name out. But in terms of what Taylor has done to overtake the movie, I mean, there was a story that came out literally 3 hours ago by Us Weekly. A source close to Us Weekly said Taylor had no involvement in It Ends With Us in terms of the production of it. Wasn't part of the movie, not a producer. She had no creative involvement. They just need to leave her out of this. She did nothing. She's done nothing. I tend to lean towards that. This is more about Blake and Ryan. I don't think Taylor Swift did anything. I mean, even if the meeting at the house, that whole thing where Ryan, Justin showed up and apparently Ryan screamed him down and called him names and why'd you say my wife was fat or whatever. Taylor just happened to be there. Like, it wasn't even like, we never heard a quote coming from Taylor saying, you're an asshole, Justin. Screw you. We're taking over. I don't know. It just seems so unnecessary. The Taylor part of this just seems so unnecessary.
So yes and no. I think I don't think there's any proof that she did anything wrong, you know, or that she should be, you know, a party to this litigation. But litigation and discovery involves witnesses to things that have done nothing wrong and have not in any way, you know, been a part of the bad behavior or the alleged bad behavior, or, you know, weren't witnesses to the most important events, right? The whole discovery process in a lawsuit is gathering evidence and discovering the facts. And if Taylor Swift was at one of the meetings that is the core of the claim, I mean, it's a pretty hard argument that, you know, she shouldn't have to be part of the discovery process just because she's Taylor Swift. right? I get she shouldn't have to be dragged into this, but people that are not as famous and without the resources of Taylor Swift get dragged into litigation to be witnesses all the time. With that said, courts are very respectful of third parties who are not a party to the litigation being unnecessarily burdened by other people's litigation. So it will be just like in every other case. Does she have to be involved? Does she have to be deposed? Does she have to provide documents? It'll be the court weighing, not that she's Taylor Swift, right? But this is a third party, an innocent, if you will, third party who's not accused of any wrongdoing, who didn't want to be part of this case, but who nevertheless may have relevant information. And so
I guess it all surrounds that conversation that apparently took place at Ryan's place. I think it was Ryan's place, where apparently it was Taylor, Ryan, and Blake versus Justin going over the rooftop scene or whatever the case may be. If she was there and witnessed behavior by Justin at that point, I would think, wouldn't Blake's team want to depose her to defend, like, hey, this is what I witnessed Justin say and do in that meeting, just as much as Brian Friedman would want to depose her to say, what did you witness in that meeting?
So Blake's team is the one that would want her to be a witness.
Yeah, to defend.
You do not have to depose someone who is a friendly witness, right? If you want, you can not take their deposition, show up at trial, they'll show up for you and just testify. That's always, frankly, an ideal scenario. You get to bring a witness, the other side doesn't know what they're going to say, and you get to bring them to trial. So typically, when you decide to take a witness's deposition, it's because it's either to fact find and to gather information, right? Or usually it is to find out what the other side is going to have them say, right? It's so that they can get Taylor Swift in a room knowing that she would be a witness for Blake, presumably, and get a heads up on everything that she has to say, right? So no, Blake wouldn't want to depose her, but Blake, you would think, would want her to be a witness. If she's not going to call her as a witness at trial, the argument for her deposition gets weaker, but she's still someone who may have relevant information. Just one example, they used her song in the movie, right? Yeah. And there's clearly allegations that Blake used her relationship with Taylor and her ability to get the clearance for, the song to be used, held it over his head, right? Taylor may have relevant information on that, right? Did she have communications with Blake about using that song? I don't see how she gets around having her deposition taken on that issue alone, or documents subpoenaed, if that's what they want to do. Again, the fact that she's Taylor Swift is not going to matter to a federal court judge, right? Yeah. It will in terms of scheduling her deposition and maybe keeping it private and keeping it in a location that's not disclosed to the media. All of that will matter, but they're not going to say, oh, she's too Taylor to depose. She's Taylor. How can you depose her? How can you make her do this?
So what starts now is the discovery phase. And do depositions happen during the discovery phase?
They're all, that's part of discovery. Yeah.
That's part of discovery.
But discovery's ongoing basically until you're ready for trial, right? The next thing that's going to happen, there's going to be some discovery, but all the motions to dismiss are going to come next.
They're not going to get, this case isn't getting dismissed.
Oh no, I don't think this case is getting dismissed. I think we talked about this earlier. Maybe some parties get dismissed. Maybe some of the defendants can show like they didn't really state a claim against me. Maybe some claims get dismissed for legal reasons, like there isn't an allegation sufficient to support claim 7, but this case is not going away.
Yeah. So either at some point during all this discovery phase, either they decide to settle or it goes to trial, right? That's
the only two way. I guess given that I don't think there's any chance this case gets dismissed, right? Yeah. Yes, it either has to settle or go to trial. Those are the only two ways it can end.
And most cases, 90 to 95% of cases get settled.
Yeah, depending on which court you're in, it's somewhere in 95% range. So
I'm wondering, I don't know. I don't know how long this goes on. I do see it. I just can't see this going to trial in March, a year from now.
Yeah.
I guess anything is possible. It would be the trial. This would be the biggest trial since OJ, honest, in terms of social media, I think.
Right, because it would not be televised.
Which sucks.
Right. So there is, the federal court is not going to allow, the Southern District of New York federal court, they do not live stream trials. Okay. So in that sense,
how would we get a daily update of, clearly it's being covered. So it would just be reporters we would have to read reporters recap of the day.
Live streaming the trial. I mean, not live streaming, live tweeting the trial, live updating the trial. Yeah, that's exactly what would happen, is you'd have reporters sitting in the room typing out, and there would undoubtedly be transcripts created. And typically trials are public events. And so, I don't know exactly how the Southern District of New York operates with respect to the transcripts, but theoretically at some point the transcripts would become public. Probably not immediately, but their trials are supposed to be public events. So there would not be, silence around it. It's just not going to be on TV. And there's not going to be anybody allowed to hold their phone and record it.
What was the last one? I feel like there was a trial sometime in the last few years where I was seeing somebody's Twitter timeline update. Oh, I think it might have been the Britney. Was it the Britney stuff?
Oh, Lori Vallow, the cult doomsday mom. I did a lot on that case. That case was not, her initial trial was not on TV. This next one is going to be, or so they say, right? They're now going to put the other guy on trial. And the judge has said he's going to allow cameras in the courtroom for that one. But her initial trial was not live streamed, I don't think.
I feel like the Britney stuff too, the conservatorship trial, because I remember reading tweets about somebody's tweets about Britney said this on stand. Britney just said this. Britney just broke down, and that was because that wasn't. It definitely wasn't televised. I would have remembered seeing the clips of that. So Britney's wasn't.
Right.
I think that's the one that came to mind. But yeah, if this goes to trial, I mean, everybody thought Johnny Depp and Amber Heard was big, which it was at the time.
Yeah.
This would blow it away.
Oh,
because of the attention it's already gotten leading up to it. Like you said last time, the Johnny Depp Amber Heard trial was big when the trial started because it was news. It was out there, but nobody really talked about it until the trial started. And then it just
right. But I think that's because of the visuals. I think that's because people got to watch what happened. I mean, I can pretty much guarantee you that if all the public had seen was was live tweets or a transcript of what Amber Heard said, totally different, right? It was people watching her on the stand that was so compelling and that, made such a, thing in the public sphere. It is very hard to evaluate how things are going on the basis of a transcript or on the basis of someone doing their best to live blog or whatever, you do these days.
We wouldn't be getting Blake's reaction up on the stand. Does she? Can we tell if she's lying? And people can judge body language and tone of voice and stuff like that.
She's pretending to cry, or oh look, she looks so devastated. I believe her. No, you're going to be relying on the 8 lucky people that win the lottery tickets to be in the courtroom, and they're just going to be saying Blake said that Justin hit her in the face and then she cried, right? Really hard to make an assessment of credibility off of that for the public. Yeah.
Will there be audio recordings at least? If it won't be
television? Very possibly. Let me see about the SDNY. Yes.
Is that Southern District of New York?
Yep. Southern District of New York, where it's likely to be. It's likely we'll get audio recordings out of the Southern District of New York. But again, they have a lot of discretion, especially for a public trial, on whether to release them immediately, whether to make them available. These are all, and individuals are not allowed to make their own recordings in almost any court, but certainly in federal court. It's a crime to record something yourself in the court. It's a crime to take pictures in the federal court. So, you don't have a guarantee that just because they audio record, we're going to be able to listen to her testimony. But I can also tell you, It's really hard to even just based on listening to someone. It's much better than reading a transcript, but it's not the same as watching them testify.
Yeah, it's really like transcript down here, listening to them a little bit better, but seeing them is ultimately what I think a lot of people will be able to base a stronger
And that's why,
opinion on.
you know, we as lawyers, when we take depositions, most of us, when we're deposing the other party or the really key witnesses, we videotape it, because you're not going to be able to show a judge he's lying based on a transcript. Sometimes, but you can just play that, you know, video for the judge and say, look at that.
Yeah.
You know?
Yeah, I think, I don't know where this thing is going. Like I said, it would be surprising if we do see a trial out of this, or it gets to trial, because we're not going to see anything. But I just, when discovery does happen, so let's say, you know, we get into discovery, how are we going to learn about that stuff? Is it once again Brian Friedman saying, hey, look at what we just found in discovery? Can he publicly just start throwing shit out there?
No.
Okay.
So publicizing, and this was kind of a focus of the hearing, publicizing a court document, something that's been filed in the court.
Yeah.
Very little argument against that, because they're public records anyway, right? So there's very little argument that putting public documents online is wrong, right? They're already online on a website called Pacer, right? Yeah. Anybody who signs up for a Pacer account can get those documents. Discovery is not something that automatically becomes a court document. Discovery is something that you send to the other side. You serve it on them. You don't file it with the court at that time. Sometimes you can file the stuff with the court for other reasons. But there's going to be a much tighter leash on that kind of stuff, because that's when you start to get into the issue of publicizing information that is not going to be evidence at trial, right? There is a ton of discovery that is done where the evidence is not going to be admissible at trial. The best example is hearsay, right? You're allowed to ask someone for all the text messages they exchanged with a third party, right? Whether you can get them in a particular case, different story, but you're allowed to ask for a bunch of hearsay. A ton of that is not going to be admissible in court, but you're allowed to ask for it in discovery to see if it leads to admissible evidence. If you start posting all of that online, that's a big problem, because now you are arguably inundating the jury pool.
Yeah, you're tainting the jury pool if you do that, because it could easily influence.
It's not going to be evidence, right? And so that's going to be a lot different than allegations that are in the complaint and this timeline of events that's part of the complaint being put online. It's much different.
Yeah, I'm just waiting for more stuff to drop. I'm wondering if Friedman has got more that he wants to put out. I feel like, because like I said, he can put out whatever he wants, but when Blake's side isn't doing anything on their end, does he need to be dropping any more? He's already winning right now in the court of public opinion. Does he have like more texts and more emails that he wants to drop and show everybody right now? To do what? You're already winning. Like you said, you're already winning.
Yeah, you're winning by a lot.
Yeah.
And, we do know that at some point, all the media saturation will become a problem. At some point, someone's going to get pissed about it, right? Yeah. It hasn't happened yet. But, the judge reminded them, and it is true, there's a line the lawyers can't cross. I would tone it down, but I also think it is starting to slow a little bit, right? They kind of pushed everything out and did the media blitz. And really, that's what the timeline was that they appended to their complaint. I think it was all their best stuff in a single place that the public could easily digest. And they attached it to their complaint for the sole reason, I believe, of being able to say this is a public court document, and I'm putting it online.
Yeah.
And so they kind of did that. I wouldn't expect to see a whole bunch of new stuff trickling out, because I think they have what they have now. And once they start getting stuff in discovery, it's going to be hard to justify putting, if they get text messages between Taylor and Blake, those should not be most likely going online, right? That's tainting the jury pool.
Yeah. And I think if anything does come out, maybe it finally comes out from Blake's side. Like we said, unless she's got this stack of evidence that she's just been holding on to. You would think if anybody's going to release anything, it's going to be her, because she hasn't released anything outside of her complaint. That's all, her complaint and her lawsuit, right? That's all we've gotten from her side.
Yeah. But, you know, they've also kind of put themselves in a tough position by A, starting the media war, but then B, complaining so bitterly about Brian Friedman going to the media. I guess if they have good stuff, they should put it out there, no doubt, even if they look hypocritical. But if they don't have good stuff, I think they gotta pick a lane and stick to it, which is we're taking the high road. You know, yeah. I got to imagine if they have silver bullets, they'd be out there by now. They did it in their complaint. They put what they thought were these really great texts out there in their complaint.
And the text just didn't have context to them.
Right. They cherry picked text messages and got caught doing it.
Have you seen anything that Justin has put out where his could be? I mean, they've claimed, I think her side has claimed Justin is cherry picking and he's not telling the full story in some of these text messages. I guess we would actually have to go through each one and be like, hey, what about this one? Do you think this could be something that's out of context? Yeah.
We'd have to see the context provided, because certainly when Blake put out, especially those texts about, look at all this, look at you dropping negative stories in the press. Without any context, how could we have known that it was followed by a, haha, we all know it wasn't actually me.
Yeah.
Right? Who would have, it never would have occurred to me that lawyers would be silly enough, I don't want to say dumb, but dumb enough to do that when it's so easy to put the counter evidence up, right? It's one thing if it's a very convoluted, if disproving something is very convoluted, but when the very next text disproves the three before it, that's pretty dumb.
And I don't even know, like, there's a part of me that, we talked about this earlier, but I'm just not understanding. Blake's complaint was pretty, I don't want to say pretty clear, but she made points of this happened, this happened, this happened, this happened. Hasn't followed it up with any evidence. She did include a few text messages, but like we said, didn't have context to them. But the big thing about that complaint that keeps sticking out to me is she said this wasn't just her, and it wasn't just her and Justin behind closed doors, and it's a he said, she said, and she's just trying to win that battle. She said that Justin and Jamie Heath, the CEO of Wayfarer, both of them inappropriate on numerous occasions and made filming uncomfortable with numerous other people. Yeah. Where are these people? Why aren't they speaking out? Why aren't they saying something on record, going on their Instagram, whatever? Nobody has said anything outside of, the Jenny Slate comment, Colleen Hoover initial statement supporting Blake, and then, Brandon Sklener with his Instagram story. But that's it. And like you said, that was, looking back on it now, while it was support for Blake, it was also very generic and it didn't have any evidence of anything. It was just, we're on her side. And it could be, we don't want to piss off the A-list couple.
That had to be it, right? To me, if I can't imagine any of the people who came out generically in support of her being the people that are going to be the ones that were harassed, because I don't know how you generically support her, see what's going on, and then stay quiet, right? I think these are people that knew who was more powerful, right? Who knew who they wanted to curry favor with, maybe even liked her more as a human, were friends with her and not with him, who knows? But, it didn't have to be necessarily a bad motive. But I think that's going to be so critical, especially because of what she's alleging, right? Which is basically he had all the power. And if there's also, a makeup artist and an assistant producer and a this, who eventually we find out he was making them feel, uncomfortable and harassing them too, it's going to completely change the tides, because it's going to make it seem like, you know what, he is a bully. He's harassing people. He's an abuser. And the fact that she's a famous A-list star is going to become less important, right? But if it's only her, this is where it goes back to the power dynamic for me. Her abuse is about power. Domestic violence is about power. And she's the one with the power in this relationship between the two of them. Yes, he was the director, but she was the one holding the movie hostage because she's the big star, not him. Yeah. And if she's the only one alleging harassment, it's a much harder, I think, thing to prove that this power dynamic was really there. Doesn't mean he couldn't have harassed her. Obviously he could have, but I don't know. And it's also going to really undermine why she came forward, why she made all those points, why she sent the email, why she had the meeting, why she filed the complaint. Because one of her big reasons is I was trying to protect the other women on set who are not as powerful as me, who couldn't speak up. And if there aren't any of those people, uh-oh.
And if those women, they don't necessarily have to file suits against Justin Baldoni.
No.
They just testify, this happened, I went to HR, it was rebuffed, or HR, because it was Justin's movie, they just kind of dismissed it, didn't follow up with anything. I think there's a lot of things, but Blake's complaint made it perfectly clear it wasn't just her. Yet we haven't heard from anybody else speak up, and you're just wondering, are they waiting? Are they waiting to do it under oath? I don't know. But
and they could be, I mean, it may be that, or maybe that they don't want to speak up because they don't, this is something they feel uncomfortable speaking up about, especially if it's people with less of a public profile, So I don't know, maybe, but that's again what discovery is for, right? She'll have to disclose everybody to the other side, right? Trials are not supposed to be surprises, right? Yeah. So that's part of the discovery process is you're not supposed to end up in a position where you go to trial and you say, oh, those are the people that you claim I harassed? Oh, crap. All of that is supposed to be vetted and put out there for everybody to know well in advance of trial. And, I don't know how she's going to defend the way she went about this if there are no other people who were harassed. I think then her whole timeline kind of falls apart to me.
Yeah. So in her complaint, she said there were others and she was protecting others and she's coming out and it wasn't just her. So during the discovery phase right now is when she would go get those people to be deposed and talk about what happened to them on set?
Yeah, so she could certainly do that. Another thing that will undoubtedly happen is Justin Baldoni will serve written discovery saying, please identify each person you claim was harassed by Justin Baldoni.
Yeah. Okay.
Right. Or Jamie Heath or things like that. And, there's a ton of stuff like that. They'll ask for documents supporting her, claim that someone was harassed. And they will find out the identities of those people. Presumably, some of that information will end up public, one way or another. But
I remember.
The other thing that's really important about whether there are other people is her motives in writing that list of things, because we know she crafted that list of things that they had to fix by saying, like, you can't do this anymore. And to me, one of the things was you have to be more respectful to everybody on set and do this for all the women. And if it turns out there wasn't anybody who was feeling unsafe, it would be further evidence to me that this was not a list prepared in good faith. It was a list prepared to make him look guilty of something.
Yeah, I mean, I remember when I went through, when I had to go through discovery when ABC sued me. So they sued me in 2011. They were like, in discovery, they asked for every email I ever sent and received from 2004 to 2011.
Right. That's always where you start.
Not just related to the to the Bachelor. It was every email. They wanted every email. I think my lawyer's response at the time was overreaching and overbearing or something like that.
Overbroad, yeah.
Overbroad, yeah. And
we get that a lot in divorce cases. They say, we want every communication between you and your spouse for your entire 20-year marriage. No, you don't need those. It has to be more reasonable than that. But discovery is broad. And because part of it is fact-finding, the courts do recognize, like, you don't necessarily know what you're looking for. So you do get to have,
you can ask, but you might not, you're not obligated to get it. Like, my lawyer responded. So if they ask, if Friedman asks, I want every correspondence, I want every text message in Blake's phone right now between her and Justin since, she signed on to do this movie.
Yeah.
Can Blake's lawyers just say no, overbroad, or do you have to like?
So what they're supposed to do is yes, you get to object that it's overbroad, but you're supposed to do what's called meet and confer to narrow it, right? You're supposed, before you go to the court and start fighting about legal objections, you're supposed to go back to them and say, look, or you're supposed to object and then they come to you and have a discussion where you say, you're not getting what about her sexy text messages with Ryan? You're not entitled to those, right? Those are private. Yeah. What about her text messages with her mother about her UTI that she had last month? You don't get those. And they say, well, of course we don't want those. And so then you say, okay, so let's figure out what would satisfy you. What if I gave you every text with Justin? Oh, well, that's a start, but we also need every text with Jenny Slate, And then she says, well, I told her about my UTI too. That's clearly not relevant. And so then they say, yeah, okay, so maybe every text message with Jenny Slate about the movie.
About the movie, yeah.
Or about Justin, and you kind of go through that and see if you can figure out something that satisfies both parties.
Yeah,
It's very burdensome. It's very burdensome. And it's very expensive.
Yeah.
Even for divorce cases where you don't have 87 people involved and $400 million claims, the discovery process could be hundreds of thousands of dollars, right? And it could be millions here, right?
And when we're talking about millions, Blake and Ryan are fine. Justin isn't. Like, financially, there's no way. It almost seems like financially, Justin Baldoni can't go to trial because that's a year from now. That's a year's worth of legal, but he'd be blown out. Yeah. I can't imagine. I mean, I don't know what his finances are.
Right. And that's the issue. We don't know. We don't know what Jamie Heath's finances are. Wayfair is one of the defendants. We don't know what kind of financial backing they have. It's not going to cost $100 million, but
no,
we don't know, but it's going to be millions of dollars if this goes to trial.
Let me just type in, what is Justin Baldoni worth? Take a guess before I pull this up. His net.
What is he worth?
Yeah.
That's a hard question. $10 million? I don't know.
I was going to guess between 5 and 10, and I'm trying to find. Isn't there a site called Celebrity Net Worth? Isn't something like that where you can find out what? Oh, Justin Baldoni net worth.
I don't think those sites have any clue what they're worth.
Yeah,
I mean, how do they know what the mortgage on their house is, right? Even those sites, I have to tell you, I've seen sites that say how much we get paid on Hot Bench. They have no clue how much we get paid. No clue, right? I mean, and I don't even know where these numbers would come from. It's not like, oh yeah, well, that's the amount I get paid for a week, but not for a month. They just have numbers on there that are just, where did those come from?
Yeah, Celebrity Net Worth, for whatever it's worth, is saying that Justin Baldoni has a net worth of $6 million.
Okay, there you go, 5 to 10. Yeah.
He's not. That's a lot. And if he goes to trial,
it's going to be half his net worth.
Yeah, it's going to be half his net worth easily, right. If not more.
No. There's going to have to be. You can't spend $5 million on trial if you're worth $10 million. So it's got to be. There's got to be something else going on, right? And there are a lot of different defendants, so who knows?
Yeah.
But.
Well, Rachel, thank you so much for this 105-minute conversation. It's ending at a perfect time because right around now, usually it's not till 9 Eastern time, but I've noticed the last few weeks the Traders episode has come out about 15 minutes early, so it should be on Peacock right now. So that's perfect timing to get to.
It's my next destination.
Yeah, to watch episode. What are we on? 7? I think this might be episode 7.
I don't know.
But yeah, we're getting good. See if they somehow get rid of Rob. The last turret is all 3 traders you can't trust each other. They're all going after each other. It's bonkers.
How do they not have Rob by now? That was
7-5 last banishment. He had 5 against him, but he was able to turn it on Wes.
I don't know. It is to me.
Everything that Derek said when he said, "Look, I want to get off this." Who are they? Whatever Tom Sandoval brought up. He's like, "All right, let's just move on to somebody that's actually worth going after here." And everything that Derek said was 100% dead on, but then Rob spun it in a way where it's just like, okay. And he convinced people. Again, he's a great talker. But again, I don't care if you don't think he's a traitor. He's Boston Rob. He's one of the greatest reality show people out there. Just get him off the show for the sake of just not having to wonder if he's a traitor or not. Just get him off.
And by the way, Derek is one of the best reality TV show minds out there too. But the fact that people don't see, like, obviously that the only way he knew that Bob was a traitor was because he was. And what better way to cement yourself than doing that? And then, by the way, if that's how good you are that you just sussed him out, why are you not dead the next night?
Yeah.
Hello.
Yeah.
So I don't know.
Yeah. Maybe he's gone tonight. We'll see. Anyway, Rachel, thank you so much. Thank you all for popping on here and sticking around. I know a lot of you stuck around the whole 90, 100 minutes. So appreciate it. I'll have this saved. It'll be up on my YouTube channel if you missed any of it. And I'll obviously link to it tomorrow as well. Rachel, thanks again. So much. And I think we're going to be, you're going to be on with Dave Neal tomorrow. I'll pop in as well.
Sounds great.
To be talking more Justin and Blake, I believe. So,
oh yeah.
Yeah. All right. Thanks again. Bye, everybody.
Bye, guys.
Okay. And